for the office of the Chief Justice by the Judicial Service Commission. I have 33 years of experience as a practicing advocate, as a judge of the High Court, and as a Court of Appeal judge. I studied law at the University of Nairobi, graduated in 1986 with a bachelor's degree of law. I proceeded to the Kenya School of Law in 1987 and graduated with a postgraduate diploma in law in 1987. I was admitted as an advocate of the High Court of Kenya in 1987 when I started practicing. I bring to the office of the Chief Justice leadership skills that I've gained over those 3 years, where I have worked as a patriotic Kenyan in transformative leadership. I joined the Law Society Council, and we were actively involved in the early 90s with the struggle, lobby, and clamor for constitutional reform, for also institutional reform like the independence of the judiciary. I was also involved as the member of FINDA in the struggle for law reforms, and I'm very, very proud of the plethora of laws that have now come into effect to protect the family and to protect children of this country. I'm proud to be associated with the Constitution of Kenya 2010 because I participated in all the major discussions, in all the major conferences, from Kamukonji to Fungamano to Bomas of Kenya, up to when we had the 2010 Constitution promulgated. I've also experienced working in the region with the East Africa Law Society, which we founded as the honorable member for Kisumu stated. We were in the Council of the Law Society that founded the East Africa Law Society and were involved in the conversations that led to the creation of the treaty and the East Africa institutions such as the East Africa Court of Justice and the East Africa Law Society, which promotes regional integration and cross-border practice. I've also participated at the Africa region, where I served for 5 years as a commissioner at the African Union. I have experience internationally representing Kenya as a delegate to major conferences, world conferences, as a delegate. I'm an accredited trainer by the Commonwealth Secretariat. I've authored a book on gender-based violence, which is used as a bench book to train judges and magistrates in East Africa on gender-based violence. I'm also accredited trainer by the Institute of International Justice from Malta on human rights. So I bring a wealth of experience from practice, practicing in the courts all over Kenya, representing people especially struggling for good governance and rule of law. In my early days as an advocate, I did not just focus on making money, but how we could improve governance, how we could enhance access to justice. Therefore, I represented political detainees. I represented persons who are charged with politically instigated offenses like treason and illegal meetings. In 2002, I was invited by the judiciary, then I was the chairperson of FIDA, to join a committee called GJ Ross, and together with judges and other stakeholders, we developed a blueprint that guided the reforms in the justice sector that are now being implemented in the various strategic plans of the judiciary, the office of the ODPP, and even the prisons and the police.
I do not want to interrupt you.
Yes.
I think that is sufficient for us.
Okay.
After all, it's a repeat of what some of us saw on the television when you are before the Judicial Service Commission. I think that is enough so that we save time and be brief. I want to open the questions, but let me give you some areas that I would like you to briefly cover, and you can do that straight away before I draw questions to members. Generally, we would like you to give the nation your vision. Your vision for the judiciary generally, particularly in improving the relationship between the judiciary, the other two arms of government. Again, bear in mind that there are complaints on funding. There are also Parliament also felt that there was overbearing conflict, possible potential conflict, when the issue or observations in Wabora case. You remember Wabora case? That judges should very, very sparingly issue orders injuncting Parliament. Also bear in mind, I'm sure you are fully conversant with Article 259 1D of the Constitution that obligates you mandatorily, when interpreting the Constitution, you must do it in a manner that contributes to good governance. I'm stating this so that you bear also at the back of your mind the advisory that was issued by your predecessor. The reflections on it, a reflection. We're seeing on it, looking at it critically. Potentially, it was possible to cause some disorder. We were happy, Judge, recently when we saw the three arms of government in the State House issuing some directives on COVID protocols. We saw the speakers of Parliament, His Excellency was there, and then we saw the acting Chief Justice, she was there, and they issued a joint communique on the COVID protocols. That is the sort of relationship I'm asking that you tell us the way to go about it. And finally, what help? That is crucial. Because your voice could be heard through this very critical oversight committee, GIRAC. What help or assistance you would like to be afforded to you by help that you, or assistance you would like afforded to you or the judiciary through this committee, which is the oversight Committee on Judiciary. Maybe you comment on those briefly. Briefly, if you have marked them, briefly where you can, and then I'll draw questions open to my colleagues.
Thank you very much, Honorable Chairman. I will start with a vision, because I have a vision for the judiciary, which I have nurtured for many years. As you know, I have applied for this position. I applied for the Deputy Chief Justice in 2011, and I also applied for the Deputy Chief Justice in 2016, and now I felt I'm ready for the office of the Chief Justice. My vision for the judiciary stems from what is in the Constitution. The Constitution is a very progressive instrument that requires that the administration of justice is always responsive to the needs of Kenyans. Therefore, my vision is an independent judiciary that is accessible, that is efficient, that is responsive to the aspirations of Kenyans. This can be done through looking at what we have already in place. We have the people who serve the judiciary, the human resource capital register, to ensure that that register is completely aligned. The job description of every judicial officer or staff is defined, and there are deliverables, and there is accountability. Honorable members, judiciary does not operate as an island. We are independent, and thankfully, the independence of the judiciary is ring-fenced in the Constitution. It's secured in the Constitution that in terms of our decision-making and hiring of staff, we will not be under direction of any person or any authority. And that is known to everybody who is implementing the Constitution, that they cannot interfere with the decision-making authority of the judiciary. However, we are accountable to Kenyans in terms of the service delivery. Service delivery is a shared responsibility. Judiciary, as the custodian of justice, is at the center of the social, economic, human rights protection, and the development, national development of the country. We cannot deliver this alone. We require the support of the legislature when it comes to allocation of budgetary resources that will enable the judiciary perform its role. We require also the executive, because if we are talking about criminal cases, the police have got to investigate the cases properly. The Office of the Director of Prosecutions has to do its bit. The stakeholders, the advocates who represent the litigants, they have to do their bit. Therefore, honorable members, this is a shared responsibility, because I am aware you are also inundated by complaints from your constituents who are trying to access justice, and justice is delayed. Therefore, this is a shared responsibility. We have to work together. We have the National Council on the Administration of Justice that is supposed to bring together all the stakeholders at the table so that we can discuss the challenges. It has been realized that passing the buck does not work, because what the Kenyan want is services. They do not just want to hear who is not doing what. They just want to know when they file a case, they will be sure that within a defined period of time, they will get justice. So it is of utmost importance that the judiciary should work together with the other arms of government, which I call interdependence. But when it comes to interdependence, it has not been defined in the law. I look at the Intergovernmental Coordination Act, which defines the relations between the national government and the county governments, complete with a mechanism of how to deal with stalemates and disagreements that occur. But when it comes to delivery of justice, the services, and we are all intertwined, we are actually a chain, there is no organ like that that can help us deal with the stalemate. But we are happy we have the NCAJ, which is thinly anchored under the Judicial Service Act. What I would recommend, we work together and come up with a bill, an act of parliament, NCAJ, complete with an organ that can enhance this kind of working relationship, and in the event that there is a stalemate, this body can deal with those conflicts. Chair, you asked about the interference of the judiciary with the mandate of the legislature. Indeed, the Constitution gives each body the mandate, and we are supposed to work with complementarity when respecting each other's area of operation. The courts give injunctions or give declaratory orders, but this is done with utmost restraint because it must always respect that lawmaking, the mandate of lawmaking is for the legislature, and they cannot be impeded in their work unless they have gone outside the parameters that are provided for in the Constitution. That is when the court is given powers of judicial review. I think that is, yes.
Before I had said that was the last, before I threw the questions to the floor, but I want you to be aware that there are certain communications and documents sent to us from 11 number parties, letters, documents. We have an affidavit objecting to your nomination from Karifa. You have seen it? It's in the file. And then 2, we have Nelson Harvey also objecting. Let me read the objections first. Harvey, I have Khalifa, Harvey, and then we have another objection from Stephen Owako. Yes, Owako, Stephen Owako, and another objection is from James Kimadi Kebuja concerning some school or something. And then, happy for you, you have 7 supporting documents. You have support from Dr. Deria, Democracy Trust Fund. You have support from John Rujikanya. You have support from Kenya Women Finance Trust. Another support comes from Alexander Kireria. You have support from Jared Nyachiro. Another support from International Commission of Jurists. That is a vital body. And lastly, you have support from Miss Lilian Wakenya Mwaura supports the nomination. So, if you can comment perhaps briefly on the objections. The support is okay, we have it. We have more, right?
Yes, thank you, Chair.
And bear in mind that some of these objections, we are aware of them because we saw you comment before the Judicial Service Commission on them. Khalifa,
yes,
Harvey, this other Oako, you commented on them. So just repeat.
Yes, thank you, Honorable Chairman. I'll be very brief in the comments. In regard to the objection raised by Mr. Khalifa, this is the third time he is raising the same question regarding a hearing of an application that was filed on the 25th of August 2017 regarding the repeat of the presidential election. An order was issued the same day on the 25th of August by the High Court declaring that all the returning officers and their deputies were illegally in office. What the implication was is that the next day, the repeat election of the president could not take place. On the 25th was declared a public holiday, but I was in Nairobi together with the bench that I was sitting with in Mombasa, Malindi. We were supposed to be working that week in Nairobi. At about 3:30, I received a call from the registrar of the court, Mr. Serem, informing me that the president of the court has certified an application urgent and I'm required to be part of the bench. That was to hear that application the same day because of the urgency. I made my way to court, arriving at about 5. I found the Honorable Mr. Justice Githinji, who was the presiding judge, and the Honorable Lady Justice Fatuma Sishale, who was also on the bench. We proceeded to court and we had the application ex parte due to the exigencies of the time. We gave an order of stay of execution of that order, meaning the presidential election could go on because of the national importance of the matter. And that decision was later on confirmed by the Supreme Court when the Supreme Court was hearing the dispute over the repeat election. They agreed that the High Court had no jurisdiction to hear the matter, and I put it in the replying affidavit, which I submitted to the court, to this honorable August House, with the judgment of the Supreme Court and the particular paragraphs where the court made that ruling. As regards the objection by Mr. Harvey, he has reiterated the same case, and he has gone on to raise another case involving Iran supplies and general contractors who are involved in the allegedly having supplied maize to the Serious Board, and they had obtained a decree to be paid some money. The Serious Board had appealed and found an application for stay of execution. So what came before us, a bench of 3 judges, Justice Githinji presiding, the Honorable Justice Malaga, and myself, was an application for stay of execution. Applying our own discretion as judges, we were of the view that it was necessary to issue a stay of execution to stop the Serious Board, which is the National Strategic Food Reserve to not to pay the money until the merits of the case was heard. Honorable members, you are aware that this matter has gone on, and the directors of the Iran have been charged of fraud. They have been convicted and sentenced to serve many years in a criminal case. And this decision goes to show the importance of a timely judicial intervention that stopped the country from losing a lot of money. The other objection that was brought to my attention was by Mr. Nurani. I haven't received one from Mr. Wako. I don't think that was served on me. It is 6 o'clock last night I received one from Nundin, but he had complained also to the Judicial Service Commission. I had responded. It is a case which was before me when I was a judge in the High Court, and he has misread this House to say that decision was appealed against. It wasn't my decision, it was a decision of another judge. So he has deliberately misread this House, and I put it in an affidavit.
You have received another support from Federation of Women Lawyers of Kenya. We have their support here. I don't know whether it's accredited to members. You can fine, very well. Then, lastly, our judges